Alright, Travis Wayne Goodsell. This is my reading of my objection to Judge Oberg's report and recommendation. I have less than 30 minutes before I'll have to take a pause to deal with a program. Let's see if I finish before that. Because I can't pause, it'll mess up the audio to picture. Alrighty. The case number is 219 CV 00711 CW DAO. As DAO is, I guess, getting dropped because she's removing herself from the case, having given her report and recommendation. So the judge I put is Clark Waddups. And the statutes for the following objection is from 28 USC 636B1A. A judge of the court may reconsider any pretrial matter under this subparagraph A, where it has been shown that the magistrate judge's order is clearly erroneous and contrary to law. Roman numeral 1, 28 USC 455. 1. 28 USC 455AB1. Your Honor, Judge Clark Waddups is well known in Utah and virally online as a fellow Mormon and is required by law, quote, shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned, end quote. 2. 28 USC 455A. Your Honor, assigned magistrate Judge Evelyn J. First. 5. Order referring case. Knowing she had been terminated from her position on the bench and was dismissed in Gaddy v. COP 219 CV 00554 C1 and 4. Or 1 and 11, sorry. Nevertheless, reassigned her to this case. Judge First held a hearing, 9-minute entry for proceedings, on 1 November 2019, with the intent to dismiss the plaintiff's complaint for failure to state a claim upon which relief can be granted, before the defendant had been served. When plaintiff finally learned of Judge First's termination, he filed motion for recusal of both Your Honor and Judge First. 12, motion for recusal. Other than the hearing on 1 November 2019, Judge First failed to exercise her duties as assigned by Your Honor, and then left her post after her last day, 30th of April 2020. 3. 28 USC 455A. Daphne A. Oberg was hired to become Judge First's replacement, and Your Honor assigned her first case to the plaintiffs. 20. Reassignment. Judge Oberg ordered the denial of plaintiff's 12 motion for recusal as moot, in quotes. 21. Order denying. When Your Honor's recusal is not moot, and Judge Oberg's order is therefore clearly erroneous on her part. 28 USC 636B1A. Judge Oberg ordered the denial of the plaintiff's 2 motions for service of process, numbers 4 and 11. 22. Order denying, thus acknowledging the plaintiff's waiver of summons upon the defense counsel. Rule 4D14, The defendant failed to waive and failed to give good cause, Rule 4D2, but acknowledged also failing to file a response within the required 30 days rule, 4D1F, by 30 March 2020, before midnight, as the plaintiff was forced to file a response before the 24th April 2020 deadline. With the defense counsel's default appearance and filing. 17. Motion to dismiss. Rule 55A(b)(1). The plaintiff filed the default status of the defendant, but the clerks failed to enter the default on the docket with the required some certain judgment requested as relief by the plaintiff. And instead the Chief Deputy Clerk, Ann W. Morgan, ordered the denial of the plaintiff's entry of default for Judge First's failure to discharge the duties of her office. 18. Clerk's order, and thus acknowledging receipt of the plaintiff's notification yet failing to discharge the duties of her office. The defense counsel also acknowledged receiving the plaintiff's reply and default notification by finally serving the plaintiff his copy of the defense motion to dismiss, 24 days in default, and the day before the plaintiff had to respond to the motion to dismiss, as the Postal Service delivered the defendant's certificate of service 2 days later on the 25th of April 2020. The day after the plaintiff's deadline for replying. 19. Certificate of service. Judge First, as previously mentioned, despite still having a week left on the bench, failed to discharge the duties of her office. Judge Oberg, upon receiving a resubmission. 23. Motion 4. Of the plaintiff's filings, which were not entered by the clerk's office on 21 April 2020, called the plaintiff's filings late. I should put default. In default. And ordered the denial of the plaintiff's resubmission. 24. Order denying. Before receiving the postal mail delivery of 24 order denying, the plaintiff filed a motion to strike the defendant's motion to dismiss. 23. Motion to strike. The plaintiff the next day filed a motion for disbarment and disciplinary action against the defense counsel. 27. Motion 4. That same day at 3:07 p.m., so that the plaintiff could not see the filing until after midnight the next day. On the online docket, the clerks entered Judge Oberg's order denying. 25. Motion to strike. 26. Order denying. The plaintiff then filed, 2 days later on Sunday, Judge Oberg's ordered amendment motion. 28. Amended motion. Judge Oberg uncharacteristically went silent as her deadline for the plaintiff came and went. The plaintiff filed a motion for Judge Oberg to break her silence and included notifications of more crimes by co-conspirators and of other co-conspirators. I should put indictments. Finally, on 6 July 2020, Judge Oberg first filed her final report and recommendation to grant the defendant's motion to dismiss, claiming the plaintiff, I should put with prejudice. Claiming the plaintiff never filed. 28. Amended motion 30. Report and recommendation. 5 minutes later, the clerks filed Judge Oberg's order denying the plaintiff's 27 motion for disbarment and disciplinary action, thus not making it in her report. 31. Order denying. Then an hour and 14 minutes after the filing of Judge Oberg's report, the clerks filed her order denying the plaintiff's ordered amended motion. As Judge Oberg recorded in her report, the plaintiff never filed, and thus was in default, and thus her recommendation to Your Honor for the plaintiff's case that the plaintiff's case be dismissed with prejudice, in accordance with the defendant's default filing, which Judge Oberg failed to acknowledge. 32. Order denying. Judge Oberg's orders are clearly erroneous and contrary to law, 28 U.S.C. 636b1a, and showing bias in favor of the defendant, as her actions might be reasonably questioned, along with the reasoning for her appointment to the bench and her assignment to this case, 28 U.S.C. 455a. 4. 28 U.S.C. 455a. Prior to Judge Oberg's appointment, she was a federal public defender. In March 2018, the Salt Lake Tribune covered a high-profile case involving Daphne Oberg as a federal public defender. Mark Porter was accused of racism, leading to the hate crime of housing rights violations. This is from the article. Daphne Oberg, a federal public defender, acknowledged in her closing argument that her client has offensive viewpoints and makes racist statements, but she said he is not guilty of the hate crime. Porter would have reacted the same way in a dispute with a stranger, no matter what race or color the other man was, she said. Mr. Porter's overreaction was an inappropriate response of an angry old man, Oberg said. She also said the case was based on intent and stressed that for Porter to be guilty of the interference charge, jurors must find that his actions were motivated by both Waldvogel's race and his occupancy of an apartment at the complex. The important thing to remember is being racist isn't enough, Oberg said. The jury disagreed with Counselor Oberg. Persons in positions of power and trust are held to a high standard. But in this case, Mr. Porter was just a neighbor whose actions were also considered a hate crime worthy of a prison sentence. How much more of a punishment should be expected if Mr. Porter was in any kind of position of authority or trust over the neighbors? Yet Counselor Oberg tried to dismiss her client's blatant hate crime with an excuse of racism is not a hate crime. In October 2010, the Salt Lake Tribune again reported another high-profile case where Counselor Oberg was defending Jolie Tibbetts, accused of a real estate scam valued at $1.2 million. From the article, Tibbetts' attorney, Daphne Oberg, said Tibbetts worked menial jobs until she was suddenly promoted to a real estate training and motivational speaking job that quintupled her income. Later, when hard times hit, Oberg said Tibbetts' life spun out of control. She kind of became involved in this fast-moving life, trying to keep up this public image, Oberg said. But it wasn't an image based in reality. Judge D. Benson disagreed with Counselor Oberg's mental diagnosis of her client, as he said of Ms. Tibbetts, "Theft is one thing, lying is another. You did both. You did them both. Miss Tibbetts was found guilty and was sentenced to federal prison. Judge Oberg has a failed history as a federal public defender whose questionable arguments have been rejected on the public record, and yet this court selected Judge Oberg to replace Judge First. Had to make a note just in case I didn't put it in here. Let's see. Judge Oberg, failed public defender whose questionable arguments have been rejected on the public record, and yet the court selected Judge Oberg to replace Judge First, who had been fired from the bench, and then Your Honor assigned newly appointed Judge Oberg to this case as her first. Were there no other qualified applicants for the position on the bench who did not have a losing record in arguing contrary to the laws of the land? Were there no other applicants for the position on the bench who had prosecutorial and defense experience in order to demonstrate a more fair and balanced perspective for the position of federal magistrate judge? So that should be a question mark. As the plaintiff has exposed bias and law violations of the clerk's office on the bench, the hiring of Daphne Oberg, whose experience is in the clerk's office and federally defending clients, has a blatant appearance of a quid pro quo. This court offered Daphne Oberg a paid job on the bench with her experience of creating failed arguments to attempt to prosecute or to attempt to protect federal defendants, in which her first assigned case is a defendant whom most officers of this court are biased in favor of. And since taking over, Judge Oberg has been ordering the denial of every motion of the plaintiff and ignoring the violations of law from the defense counsel. Judge Oberg is clearly showing bias in favor of the defendant, as she is arguing erroneously and in clear violation of the law. 5. 28 U.S.C. 455A. In Russia, their economic system is run on mafia extortion. Their tactic is called kompromat. There are two forms of kompromat utilized by the Russians. One is manufactured kompromat. Manufactured kompromat is when lies are created or manufactured and documents altered, even photos and audios and videos are manipulated so as to compromise an individual to conform and comply when they are reluctant to do so and have lived a good and spotless life. The second is complicit kompromat. Those who are corrupt become co-conspirators willingly. Such individuals with complicit kompromat are susceptible to taking the fall as a scapegoat, allowing those holding the kompromat over them to be distanced from any accountability. Judge First was terminated because of a manufactured kompromat of a past case where she lawfully referred a non-violent drug offender to Utah's drug court. Judge Oberg was hired to replace Judge First, already having just cause from her history of failed federal court arguments. Her instant termination home. Her instant termination if she failed to conform and comply with her first assigned case for which she is being paid for. Somehow doesn't sound right. Let's see. Judge Oberg was hired to replace Judge First, already having just cause for her history of failed federal court arguments. Already having, okay, for her instant termination if she failed to conform and comply with her first assigned case for which she is being paid for. Judge Oberg's clear bias in favor of the defendant shows her complicit compromise. 6. Again, 28 U.S.C. Code 455A. In notifying the parties of her report and recommendation, Judge Oberg quoted the law, despite clearly targeting the plaintiff, as he's the only one negatively affected. In showing bias to the defendant, in favor of the defendant, Judge Oberg is washing her hands of the case to dump it in Your Honor's lap, knowing Your Honor is, as the plaintiff, as a Mormon of the defendant. Got 5 minutes. Judge Oberg referred to the defendant as the church rather than the corporation, again showing bias in favor of the defendant and attempting to influence Your Honor's decision to not separate the corporation from the religion. Religions are protected under the First Amendment, such that religious teachings and doctrines are protected as long as they do not promote hate crimes or other criminal activity, but as a corporation, the defendant is subjected equally to the laws of the United States as any other corporation. For this reason, the federal law clearly condemns any judge to be a member of any church of which is a party to whom such judge is overseeing, as it clearly tempts such a judge to be impartial in the performance of their duties. Okay. Let me take care of this now. Now I can go straight through. A number of section number 2. A number of constitutional violations of law, and of court process and procedure have occurred warranting Your Honor's reconsideration. 1. The First Amendment of the Constitution of the United States of America. The plaintiff, utilizing the federal court as the last resource to petition for a redress of grievances, as no executive enforcement agency or prosecutorial agency would render assistance, is therefore to be granted leniency as a pro se litigant and filing in forma pauperis by the court. The defense counsel, on the other hand, are educated in law, degreed, have passed the bar, been licensed to practice, hired by a law firm, and have been assigned to this case. As such, the bar for the defense counsel is much higher in following the law and court processes and procedures, and in getting their client to be on their best behavior during the duration of the case. Their client and any co-conspirators. And any accused co-conspirators to be on their best behavior during the duration of this case. The defense counsel filed in default a motion to dismiss with prejudice to deny the plaintiff his First Amendment rights. If the defense counsel had filed on time in accordance with court filing timelines, the defense counsel claimed in their statement of relief sought two general claims. One, the plaintiff's case is frivolous on its face, and two, the plaintiff's case fails to state anything close to a cognizable claim. Rule 12b lists 7 grounds for the defense to properly file a motion to dismiss: lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted, and failure to join a party. Under Rule 19, which needs to be de-hyperlinked and blackened and de-underlined. Okay, the defense cannot motion to dismiss because they disagree with the claims or with the accusations. As such, the defense counsel failed to respond to each and every of the 46 counts of the plaintiff. Okay, it's blue because I don't have a comma, and I have an extra space. Generalizing them all as containing insufficient facts, as frivolous or frivolous, not cognizable. As the plaintiff ordered his counts under each, is that capitalized? Come on. Under each accused violation of law, the defense's motion to dismiss is instead frivolous, as it fails to state a proper claim upon which relief can be granted. Turning it back on them. The plaintiff filed these facts in his second reply, after receiving the defense counsel default reply. The clerks failed to enter the plaintiff's motions. Judge First failed to respond, and Judge Oberg ordered a denial, stating the plaintiff was instead the one filing a counter-reply in default, and agreeing with the above arguments of the defense, ordering the plaintiff file an amended counter-reply within 14 days. I remind Your Honor that on 1 November 2019, Judge First held a hearing to dismiss the plaintiff's complaint for failure to state a claim upon which relief can be sought, but granted the plaintiff 30 days to file an amended complaint, which amended complaint was filed in a timely manner and was approved, as no other hearing was held to dismiss the amended complaint, thus requiring the defense to respond and deny any attempt to file their motion, thus requiring the defense to respond. And denying any attempt to file their motion to dismiss. And they were supposed to respond differently, and instead they used this. Well, I'm not going to comment. I'll just read it as I have it, because I go into it later. So maybe thus requiring the defense to respond and not submit any attempt to file their motion to dismiss. 28 CFR 68.10 or whatever. It should be noted that in Gaddy v. COP, the counsel for the defense filed in a timely manner their motion to dismiss. For example, the plaintiff filed the first counts under Roman numeral 1. Counts under Roman numeral 1. RICO Act, USC 1961-4. Enterprise including any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact, although not a legal entity. Count 1. The defendant claims true succession from the 1830 organization. Evidence shows the defendant is not the legally recognized successor in the decision of the Reorganized Church of Jesus Christ of Latter-day Saints, complainant v. The Church of Christ at Independence, Missouri. The defense failed to explain how a United States court case is an insufficient fact, or in their words, frivolous on its face, and fails to state anything close to a cognizable claim. There has been a trend currently to legally claim truth is not true, reality is not real, facts are not facts, evidence is fake news or a hoax, and crime is not a crime. It appears the defense counsel is up with the times and has convinced Judge Oberg to join in this frivolous and dangerous defense argument abused by the defense to deny the plaintiff his First Amendment rights and make the defendant immune from prosecution. 2. The plaintiff has been catching and presenting evidence of the defendant, the defense counsel, co-conspirators listed in the complaint, and court officers, and even Utah Governor Gary Herbert in criminal actions to tamper with the proceedings of this case, including death threats and internet crimes against the plaintiff, of which the defendant is exposed financially. By Judge Oberg's orders of denial against the plaintiff, even the motions for disbarment and disciplinary action against the defense counsel, the plaintiff is not just at risk of a denial of justice, plaintiff is not a she, but Judge Oberg is also placing his life in jeopardy from retaliation to the level of death threats, additional years disappeared, and financial reprisals, including online and public censorship. 3, section number 3. Judge Oberg's clear and apparent bias for the defense and her commission in criminal activity in violating the United States Constitution, laws of the land, and rules of the court implicates her as a co-conspirator. 1. The plaintiff filed in the jurisdiction of RICO conspiracy and listed numerous individuals as co-conspirators. In accordance with the laws under the definition of conspiracy, a conspirator may be held liable or legally responsible for the crimes committed by his co-conspirators, even if he did not personally commit the crimes. A conspirator can be charged with both conspiracy to commit a particular crime and also with the crime itself in cases where the crime was completed. As such, Judge Oberg is implicating herself in the crimes of any and all other co-conspirators listed in the plaintiff's amended complaint, and subsequent motions for which she has ordered denied. Judge Oberg is likewise implicating the defendant in further counts of guilt for her erroneous and contrary to law orders. 2. Judge Oberg has ordered denials of motions by the plaintiff presenting evidence who presented evidence of tampering and obstruction with these court proceedings. It is clearly erroneous and contrary to law to order denials of or quash indictments of information or information made by the plaintiff, just as it is for defense indictments or information made. 28 U.S.C. 636 B1A. 3. Judge Oberg dismissed the plaintiff's ordered amended reply for failure to state a claim upon which relief can be granted, a clear, erroneous order contrary to law. 28 U.S.C. Code 636 B1A. 4. In referring to the defendant as the church, Judge Oberg not only showed bias, but committed a religious hate crime against the plaintiff. The religion of the plaintiff is the same religion of the defendant, and has made it very clear that the church is not the defendant, but the corporation running the church. Judge Oberg's previous court argument that racism is not a hate crime was rejected. So too would any argument claiming that religious bigotry is not a hate crime, especially since Judge Oberg is not just a neighbor, but is in a position of federal judicial office on the bench. 5. It is a modus operandi of the defendant to abuse the motion to dismiss for failure to state a claim upon which relief can be granted. Such abuse is contempt of court, as it places the burden upon the federal judges to be extorted into ordering for the defendant and denying the First Amendment rights of the plaintiff. Failure to comply with the defendant's extortion demands results in termination of employment, as is what happened with Judge First, as she was given a second opportunity to rectify the situation without further reprisals by assigning her to the plaintiff's case to dismiss it in accordance with the extortion threat already carried out. This indictment is not only against Judge Oberg for her complicity with the extortion demands as a co-conspirator, but to any and all judges in the district court who fired Judge First and replaced her with the hiring of Judge Oberg. In the Miranda warning, it states that anything the defendants say can and will be used against you in a court of law. It has been clear that the plaintiff's complaint is a RICO conspiracy, and thus anyone which in this case are the defendant and any and all co-conspirators who says or does anything can and will have such used against them in court. For a federal magistrate judge to dismiss an indictment of herself, for a federal magistrate judge to dismiss an indictment of themselves, should be of themselves, because I put a federal, let alone anyone else, is clearly erroneous and contrary to law. And Section 4. One of the death threats against the plaintiff by both the defendant directly and by co-conspirators commenced during this case, for which Judge Oberg has ordered a denial, is the escalation of coronavirus. The plaintiff has already listed a number of counts under the accusation of treason, and with Judge Oberg's complicity as a co-conspirator, biased for the defense, biased in favor of the defense. Come on. No, that's not what I wanted. In favor of the defendant. Also implicates her in the accusation of treason against the United States in threatening the life of the plaintiff and makes the defendant liable. In also against the United States in also threatening and also threatening the life of the plaintiff and makes the defendant liable. 1. Regardless of whether or not Fox News is correct, regardless of whether or not Fox News is correct in suggesting coronavirus was man-made in a science lab in China is irrelevant, as the response of national, state, and defendant leadership's disregard for health officials' warnings before the virus became a pandemic and continuous disregard is an act of treason. The defendant's CEO is also a world-renowned medical doctor, yet disregarded his own education and experience Hippocratic oath. Is that correctly spelled? It looks like it is. Yep, Greek medicine for Hippocrates. Let's see. And Hippocratic oath to do no harm. With his religious position, let's see, is also a world-renowned medical doctor, yet disregarded his own education and experience and Hippocratic oath to do no harm with his religious position with 2 religious fasts to cure the virus. All involved rushing to reopen businesses, downgrade to green, and deny further unemployment funding as the virus was rising. The consequences of this disregard are an escalation in infected, hospitalizations, and deaths of many Mormons, Utahns, American citizens, and human beings worldwide. This act of genocide is treason perpetuated daily with no intention to cease this deadly course of action and start protecting and healing those lives remaining, including the life of the plaintiff, petitioning for a redress of grievances against the defendant and their co-conspirators during this case. Life of the plaintiff petitioning for a redress of grievance. No, that's... including the life of the plaintiff. Having a pending petition for a redress of grievances against the defendant and their co-conspirators. The defendant's participation in the escalation of the virus also caused communication problems with the plaintiff and the court, as plaintiff's motions were not filed by the clerks, and confusion over the defense counsel's default. Okay, it doesn't look like I'm going to be putting this in. So the concluding statement. Confirming the bias of Judge Oberg, leading to her commission of erroneous and contrary to law orders, implicating her as a co-conspirator for which the defendant is liable, has committed acts of treason in her first assigned case as a newly hired federal magistrate judge. Such unbecoming conduct and contempt for her brand new position on the rising to the level of being unfit for the bench is likely to be a judicial misconduct filing pending the outcome of this case. Judge Oberg's first assigned case in her brand new position, and she starts with a complaint. Judge Oberg's first assigned case in her brand new position, and she starts with a complaint. Okay, this is where I needed to add in what I had written down earlier. There are watchdogs waiting to learn of Judge Oberg's history on the bench as they watch every judicial officer across this nation. All such observers will know how she rules. And therefore will know of this, her first case and recommendation. As a pro se litigant, the plaintiff has proceeded in good faith as the defense counsel has acted in bad faith to extort the court to quash the plaintiff's legitimate claims. The defendant didn't even assign their best legal counsel to the case, showing again the defendant's contempt for the court and the court processes and procedures, as the defendant's Seagull Gate symbolism is meant to also apply to the federal court as well as the state government. The defendant and their co-conspirators have sent the plaintiffs a clear threat and intimidation to back off from this case with a show of dominance in all venues of the plaintiff's life. The plaintiff was forced into this position to file a complaint because of the threats and intimidation previously by the defendant and their co-conspirators, who will not leave the plaintiff alone to live out his life. As Your Honor is a fellow Mormon, you are aware that the defendant's leadership claim to be prophets, seers, and revelators, but they never acknowledge being translators. The plaintiff merely pursued a life to learn if the Mormon founder Joseph Smith Jr. was correct, and how the rest of the facsimiles are to be Egyptian facsimiles. Facsimiles in the book of Abraham are to be translated. It never occurred to the plaintiff that Joseph Smith would be wrong, but it definitely never occurred to the plaintiff that he was forbidden to pursue a faith in Joseph Smith as a translator. As the plaintiff let evidence lead to the truth and facts, he deciphered Paleo-Hebrew, confirming Joseph's retranslation of the Hebrew text of Genesis 1:1 in his King Follett sermon as correct. Or he confirmed was correct. That works. The plaintiff then went on to decipher ancient Egyptian petroglyphs, as Egyptologists only translate the texts. The plaintiff went on to confirm Joseph's method of translating the facsimiles in the Book of Abraham was correctly done, as the plaintiff discovered that this method was the same method used to write the biblical stories that are mistaken as historical only. Never at any time did the plaintiff believe he was going against the defendant. Yet that is exactly how the defendant perceived the plaintiff. Only in retrospect does the plaintiff now understand that by becoming a translator to confirm Joseph's work, he exposed the defendants as frauds. This enlightenment was soul-crushing to the plaintiff, to understand why his own religious people and organization would hate him to the point of committing crimes to silence and censor the plaintiff into ignorant conformity and submissive compliance. To learn that the CEO and board of the defendant were directly involved in committing crimes against the plaintiff was also soul-crushing, as before this realization the plaintiff chalked up fellow Mormon abuse to individual ignorance of Mormonism. Instead, Mormon hatred has been taught within Utah Mormon culture, as the plaintiff, no personal pronouns, plaintiff had been warned about Instead, Mormon hatred has been taught within Utah Mormon culture, as the plaintiff had been warned about by peers as a California Mormon. This oral tradition of hatred has rewritten the Book of Mormon, creating corrupt doctrines to justify crime and create blindness to the observance of the corrupt and criminal examples represented in the Book of Mormon. But then to see for myself from my wedding photos at the Salt Lake Temple the sign of the fallen star of Lucifer from Isaiah 14:12, copied into the Book of Mormon in 2 Nephi 24:12, was not just soul-crushing, but sent utter horror throughout my body, as I now knew why Mormons and the I should put Utah Mormons and the defendant's leadership embraced the bad examples from the Book of Mormon. The church of the defendant is not the church Joseph founded, nor was it a church of Jesus Christ. It is the church of Lucifer, with the doctrines of Lucifer, and their treason is not just against me, but against Utah, the United States, the world, and to all mankind. The defendant has used the cloak of religion to mask their crimes, as this is the true intention of the religious freedom movement that the defendant has joined evangelicals for. Your Honor must acknowledge your affiliation to the defendant, but the only way to stay on this case is to show your loyalty is not to the defendant, but to the United States and to the laws thereof, and order in favor of the plaintiff with prejudice, and do so in a speedy manner, immediately followed by an order for criminal indictment as stipulated in the law of the defendant, as the grounds herein and in the plaintiff's complaint, amended complaint and motions, complaint and subsequent motions, are clear beyond any reasonable doubt. And I need to put in, as he would have gone through the temple when we were told to commit suicide for violating the secret oaths of loyalty to the church against the United States. But that is it. And I'll end it here. I'll type in the temple death threat that we're supposed to commit suicide, and then email it, and then I'll upload this video. So by the time you see it, I will have already sent it in. The additional part was longer than I anticipated, so I'm going to read it to you instead. Let's see. Okay, so right after the defendant has used the cloak of religion to mask their crimes, as this is the true intention of the religious freedom movement that the defendant has joined evangelicals for. Your Honor's publicly listed age reveals that you too have been endowed in the defendant's religious temples before 1991, when we were ordered by covenanted oath to commit suicide if we were loyal to the United States over the defendant's organization in the law of sacrifice, the law of the gospel, and the law of consecration. Your Honor must be informed that the defendant was disincorporated under violations of the Edmunds-Tucker Act, and as such act was rescinded in 1978 with the quid pro quo to have the defendant allow blacks into the temples The defendant, with their most recent change to the law of chastity, promotes the eventual return of the defendant to polygamy, which is human sex trafficking. By referring to the law of God instead of the previous laws of the nation, which is a reference to Section 132, falsely attributed to Joseph Smith, the founder. Okay.